Morning, everyone. Good morning. My name is Rob Malone, and I chair the business practice group here at Buckingham Boroughs. And we started this Breakfast with Buckingham program about 2 years ago as an opportunity to provide our clients with information that we thought they would find of interest. And certainly this topic seems to have drawn a lot of interest. The program's been so successful, we built this new space for the program and also to watch winning football games. We haven't had a lot of those lately, but we're hopeful that we'll have some in the future when they start televising Mount Union games. We have a few of our Mount Union alumni here with me this morning. Our topic for today deals with a recent Supreme Court case that involves, can't hear? Okay. A recent Supreme Court case that deals with the issue of when an individual who lives part-time in Ohio will be treated as a resident of Ohio for income tax purposes. This case affected a major change in the law. And here to discuss that case are three members of our income tax and tax and trust and estates practice group: Steve Domingo, who chairs up our tax practice group; Rich Fry, who works with him; and Ron Wayne from our trust and estates practice group. We ask that you would hold your questions during the course of the program to make sure we get through it, but they'll remain afterwards to answer questions for free, so take your chance to take advantage of that. This was a special bonus with breakfast program. We do 4 of these a year. We're doing 5 this year because this was such a hot topic after the Supreme Court issued the case this summer. We have one other program scheduled on November 4th dealing with litigation matters, and look forward to seeing you at that if you'd like to attend. Without further ado, let me turn the microphone over to Steve, and we'll begin our presentation. Steve?
Okay, thanks, Rob. Good morning. Morning. This is all about residency, and let me just give you a quick little insight concerning what's happened, and we'll obviously go into more detail. What's happened was, from a historical perspective, we quite a while ago, we were working with a lot of uncertainty that was tied to a test of as to whether somebody was a resident or domiciled in Ohio, a common law test or a case law test, which was very, very subjective. Then the Ohio's legislature spoke in the early 90s, the General Assembly, and gave us clarity, some certainty that we thought solved the problem. Recently, the Supreme Court spoke, and that clarity was eliminated. And we're here today to talk about what's going to happen, what we anticipate happening, and how to minimize risks associated with the residency question and how you might plan in the future. So let me give you another historical perspective even further to kind of delve down into that. And this morning I listened to a good quote from CNBC that says, there's an advantage to living history versus knowing history. And we certainly lived this history with respect to the domicile test, the residency test, back in the late 80s, early 90s, when significant audits were occurring. And the typical scenario would be, with respect to those audits, would be you'd have the classic scenario to be the wealthy, this kind of use this as an example, the wealthy rubber executive compiled a lot of stock, options, regular stock, deferred compensation, pension plan, and so forth. And then in conjunction with having a home outside of Ohio or actually obtaining a home outside of Ohio, they contemplated changing their residency. And immediately after that move, realizing that substantial portion of income, more of a passive nature, the investment income, the pension income, and so forth, and not pay Ohio tax on that. And so the tax commissioner would challenge that through these domicile audits. And if you've experienced them, and Rob and I had quite a few of them, and we resolved them, I think, fairly successfully, you had to complete a 8-page residency questionnaire, that any question you could think of, because all of this was trying to ascertain the intent of the individual. Was the intent of the individual, as Rich is going to go through what the test is, was the intent of that individual to be outside Ohio for an indefinite period of time, and most importantly, abandon Ohio. So about any question, any fact you can think of with respect to somebody's life, is relevant to that question. The classics are where you vote, car registration, where your financial accounts are, but then they also asked questions concerning country clubs, utility bills, doctors, credit card statements, veterinarian, where your vets were for your pets. And I always thought the classic question that really brought home the question, because the test is, as Rich will go into more detail, is the place that your domicile is the place where you intend to return. And the ultimate test, I thought, was one question on those different questionnaires, and that is, where's your burial plot? If it's in Ohio, then obviously you intend to return to Ohio. But in any event, there was much uncertainty there with respect to pinpointing where your domicile was. And hence, we had a bright line test that was enacted in the early 90s to add some clarity. But 2 months ago, actually early July, all of this stopped with the Supreme Court's decision. Gives us a timeout and essentially eliminated this safe harbor that we've relied upon, this bright line test that we'll go into more detail, the safe harbor for more than 20 years, that really provided the certainty. We all thought all you had to do was have X number of days outside of Ohio and a home outside of Ohio the entire year, and everything was done. No problem at all, regardless of what your intent was. And Cunningham tested that. That safe harbor, known as the bright line test, even allowed you to have your predominant connection to Ohio. You could concede that you are primarily tied to Ohio, as evident by the change in the test to now allow almost up to 7 months to be in Ohio. And your spouse could even have a different domicile, which would be drastically different than the common law test, because the common law contemplates that you both would ultimately return to the same location. But again, all of that vanished with the Ohio Supreme Court. And so what we're going to talk about today is, the importance of resident status, the historic tests, the common law test for domicile, and the bright line presumption. Rich is going to go into detail of that. I'm going to talk about the Cunningham case and what we anticipate some legislative fix, and then Ron's going to conclude with some estate planning issues with respect to Florida domicile versus Ohio domicile. Okay, resident. Let's give you some more background. Ohio resident is somebody that has an Ohio domicile. And again, we have this bright line test that focuses on the number of days you're outside of Ohio. And we'll go into more detail concerning that. Why is residency important? If you're an Ohio resident, you're basically taxed on all of your income, and you get a credit to the extent of any income tax paid on that income outside of Ohio, but your credit is limited to the Ohio tax that would have been owed on that income. Then here's the play for the non-resident. They're taxed on only the income, regardless of where it's taxed, but only the income that's deemed to be earned in Ohio, situs in Ohio, has a deemed location in Ohio. And we have a couple statutory provisions that tell us where income is deemed to be earned. In particular, the statutes tell us that retirement income is deemed to be earned where you're domiciled. So, and that's based upon a federal preemptive statute that says if it's retirement income, then it's not taxed, even if it's non-qualified income that meets the definition of retirement income. And retirement income can include income that is just paid out over your life in substantially equal payments, or paid over a 10-year period of time, at least substantially equal payments, or a plan that's intended to supplement a non-qualified plan. So there's some other definitions as to what constitutes retirement income. Investment income, dividends, capital gains, etc., are not taxed only taxed to the state of domicile. Non-compete payments aren't deemed to be taxed in Ohio. And then finally, the business income is only taxed to the extent it's earned in Ohio. And then finally, we have a pass-through entity provision that deems certain income to be earned in Ohio from the disposition of a sale of a pass-through entity. And that's a very complicated provision that is at issue now before the Ohio Supreme Court. So Rich is going to talk about our historical tests.
All right, so now we know what the advantages and the benefits are that we're trying to seek with becoming non-resident. I'm going to talk about what the tests are for how you determine whether you're taxed as an Ohio resident for income tax purposes. And as Steve said, resident is defined as someone who's domiciled in the state, and it's determined by this common law test that's been established over many, many years. And the test is actually used for other purposes besides income tax, such as voting, where you can run for office. So there are other applications for this test. The key distinction between a residence and a domicile is you can have multiple residences, but you can only have one domicile. So under the common law test, the definition of domicile is where the person's permanent legal residence, where they intend to stay for an indefinite period, and where they intend to return. So we're focusing on this intent to remain indefinitely and intent to return. Very subjective test. Also, think about it in the context of an income tax audit. You're trying to prove this intent, maybe 3, 4, 5 years after the fact, after you've tried to change your residency. So the cases generally are going to come down to a balancing of many different factors, what they call objective manifestations of this intent. So we're looking back, 3, 4, 5 years, trying to show that this person who tried to change their domicile acted consistently with that intent. Another aspect of the common law test is that there's a presumption that domicile continues until it is abandoned. So the burden is going to be on the taxpayer under this test to prove that this intent changed, that they abandoned their Ohio domicile. So think about that in the context of a retiree or a snowbird. They have this long established history of being domiciled in Ohio, and now they want to change their residency for income tax purposes. But normally they're going to retain their Ohio residence. They're going to come back here in the summer, come back to see family, come back for holidays. So did you ever manifest that intent to abandon Ohio? So it's very, very difficult to overcome this presumption when it's challenged. So as Steve mentioned, in the 80s and 90s, the tax commissioner really ramped up efforts to audit high net worth individuals who had been retiring and realizing this kind of intangible investment type income, but they were claiming non-Ohio residency for income tax purposes. And they would send out this very extensive questionnaire with several different questions. And then it would turn into this balancing of, okay, how many factors are in favor of Ohio domicile? How many factors show that you that you attempted to change your domicile? And like I said, very subjective test, but also very intrusive on the type of information you had to provide and the type of questions that you had to answer. So I'm just trying to go through a few of the factors that are up here on the screen. First is voter registration and where you actually vote. This has been cited in many cases as being the most critical factor in determining domicile, and that is because of the significant legal tie that you have to the community or the location where you vote. You're actually involved in kind of shaping that community, through voting. Second, with respect to residence, the question is only going to arise when you have multiple residences. So what are we going to look at? We're going to look at, okay, where are these family heirloom type items? Did you take your, family pictures from Ohio to Florida when you tried to change your domicile? Also, what residence is more luxurious? Maybe you have this, very nice house in Florida, nice art, nice furnishings, and in Ohio, maybe you have a, smaller condo, nothing on the wall. You're just here when you're visiting family, or you're just here for your business interests, but not really the center of your life. And then several of the factors you'll see very intrusive as far as business interests, where do you bank at, what professionals you use, and I'm going to talk a little bit more about this later, but you can understand, if you came to us and said, all right, what do I need to do to change my income tax residency to Florida, the last thing we want to tell a client to do is, well, you got to fire your lawyer, or you can't go see an Ohio doctor, you got to go see doctors in Florida. So you'll see kind of the evolution of this is, well, there are certain things that are bad for Ohio businesses that the tax commissioner was looking at, and maybe we need to change that. Address used for official purposes. Obviously, the address that you list on your tax return or motor vehicle registration, they're going to look at all those things. Same thing with participation in social, religious, and civic organizations. We don't want people to make the decision, oh, I can't participate in an Akron charitable organization because that might be cited against me in an income tax residency determination. So very difficult to navigate, and it was becoming more difficult due to the intensity of the tax commissioner's inquiry through this questionnaire. So the case that really brought this to a head was Davis v. Limbach. It was a 1992 Board of Tax Appeals case. And the individual had Ohio business interests but was becoming separated from his wife. The wife got the Ohio home. He got a home in Florida, and for the year in question did not have a home in Ohio. But he continued to come back here to tend to his business and also used the business address for mailing purposes. He also made what I'll call the mechanical type changes. So registering to vote, driver's license, opening a bank account in a Florida bank. So all those are objective manifestations of his intent. And the BTA found that he was not domiciled in Ohio, mainly relying upon this critical fact that he didn't have an Ohio home for the year in question. This was important because it stood for the proposition that you didn't have to sever all your ties with Ohio. You can still have some ties with Ohio, yet change your domicile. But the real, the most important quote is this quote at the end here. There is no bright line test stating exactly which factors are necessary for an individual to effectively change their domicile. So this began the realization of, hey, we need to have more certainty. We need to allow people to be able to know when they can change their domicile because it's really a really gray area. So the next year, 1993, the General Assembly enacts the Bright Line Residency Test. And this statute is a series of residency presumptions based upon your Ohio contact periods. And contact periods essentially are trying to determine overnight stays in Ohio. And that's why you have the definition of spending 2 consecutive days in Ohio, or any part of 2 consecutive days in Ohio. Now, the other important part about the contact period test is that it's only when you're away overnight from your non-Ohio abode. So if someone literally flew back to Florida every day, they could be in Ohio every day and never have a contact period, as long as at the end of the day they fly back to their non-Ohio abode. Now, maybe a little more realistic if you live in Pennsylvania or Kentucky, somewhere where you drive over the border, but it's not just spending 2 parts of every day, it's when you don't return home at the end of the day. An important part of this test, though, is that it does not apply to part-year residents. So it's never going to protect the person in the year of the move. But it does provide some planning opportunities. If you anticipate recognizing a lot of income, let's say in 2016, maybe you want to start taking those steps now so you can say, December 28th, my intent changed and I abandoned my Ohio domicile. Or, kind of conversely, if you know you're going to recognize a lot of income in 2016, but maybe you're not going to close on your non-Ohio house, or it's not going to be ready for construction. Maybe I want to lease an apartment in Florida so I can satisfy one of the elements of the Bright Line test, which is having an abode outside the state for the entire year. So this is where a lot of planning comes in as far as where you want to fit in that year of the move. The real crux of the Bright Line test is this irrebuttable presumption. To meet this, or to raise this presumption, you have to have a non-Ohio abode for the entire year, meet the contact period test, which I'm going to talk about here in a second, and then file a non-Ohio residency affidavit. As part of that affidavit, you swear that you were domiciled outside Ohio for the year at issue. And practitioners and really everyone who relied upon this for the last 20 years thought, well, if you satisfy the non-Ohio abode and you satisfy the contact period test, they could never challenge that statement in the affidavit. But you see at the bottom here, the last part of this quote, and this is what tripped up the taxpayer in Cunningham, is if you make a false statement, they challenge that statement on the affidavit that said that he was not domiciled in Ohio. Originally in 1993, when it was enacted, the contact period test was set at no more than 120 Ohio contact periods. There's also a 30-day exception for being in Ohio for medical emergencies. So effectively, you could not be in Ohio for more than 150 days. So still, a significant majority of your time was spent outside Ohio to meet this test. In 2007, they increased the presence in Ohio that you could have essentially to a 50-50 test. So if you spent more time outside Ohio than in Ohio, then you could meet that test. They also did away with the 30-day exemption for medical purposes. Then in 2015, kind of ironic, the same year that this case came out, they increased it even more, consistent with Governor Kasich's policies of reducing income tax burdens, Ohio income tax burdens on taxpayers, especially small business owners. They increased it to 212 Ohio contact periods. So effectively, you could spend up to 7 months in Ohio, yet still qualify as a non-resident under this test for income tax purposes. Also in 1993, the tax commissioner was ordered to publish a rule as to what factors would be considered and what factors were irrelevant for a domicile determination. And I said I'd come back to some of these factors that were on the questionnaire. Basically, Ohio made a policy decision that, hey, it was bad for Ohio business to have people think about changing these aspects of their life and severing these ties with Ohio businesses when they're changing their domicile. So things that cannot be considered in the domicile determination are what banks you use, what investment brokers you use, professional service providers. We want to give an incentive for people, even if they're not Ohio residents, to use Ohio doctors and lawyers and accountants. Civic and charitable organizations. Obviously, same determination. We want to give an incentive for people to, or I guess not have a disincentive for people to participate in Ohio charitable organizations. Passive business interests. So investments in a small business where you're not actively managing it. Another thing that we want to encourage non-residents to participate in. Schools attended by dependents. We don't want people to make the determination that, hey, I'm not going to send my child to Akron University because I don't want that cited against me in a residency determination. So you can kind of see all these things are factors that we don't want, or that would hurt Ohio business if we made people change that in conjunction with changing their residency. So what factors are relevant? Much shorter list, although all-inclusive at the end. First is contact periods. It's always going to be relevant how much time the person spends in Ohio. Secondly, comparison with previous years. When we're involved in these cases, what we always try to show is we're looking for some significant change in life. So, did you retire? Maybe if there was involved in a family business, maybe some type of succession planning was implemented. So before, I'm spending 50, 60 hours a week managing this family business on a day-to-day basis. Well, now I've cut back some of my responsibility, and we're trying to pass those responsibilities onto a younger generation. So we're trying to build in some type of change in life that we can show as part of the intent to abandon Ohio domicile. And then finally, any other factor that's not excluded from the determination. So it could be a pretty broad range of things that are considered. So with that, I'm going to pass it to Steve to talk about the recent case.
Okay, I think I could try this again. I was overheating there the first session. I think there's a prankster that put some heat lamps or tanning lamps here, but man, I was too hot. In any event, let's go on to the Cunningham case. And this was just set up to test the bright line test. It was, I always think in the back of my mind, it's an in-your-face. We're going to give you all the facts. You just decide this. We're going to concede all the facts that you think are relevant, and we're just going to test this legal principle. And so in Cunningham, they met the contact period test, had less than 183 Ohio contact periods, which was the test for the years at issue. They also had a Tennessee home outside the state for the entire year, and they timely filed this affidavit that says that they were domiciled outside the state for the entire year. And the Board of Tax Appeals had said, well, that was sufficient. As long as those first two tests are accurate, then that's all we focus on. And in this case, though, they had a contradiction. They filed a homestead exemption application that recited an Ohio home as their principal residence to obtain the few $1,000 benefit associated with the Ohio homestead exemption. That was inconsistent with the domicile affidavit that was filed for Ohio income tax purposes under penalties of perjury. Both those statements were filed under penalties of perjury, and I know former tax commissioners have said that under this bright line test, all they can do is throw you in jail if you're lying on the affidavit, but they can't tax your income because the test for determining whether you met the bright line test is only with reference to the home outside the state for the entire year, and you met the contact period test. And this was the in-your-face statement. They agreed that they were domiciled in Ohio from a common law perspective. So this was a classic set of circumstances for the Supreme Court. And again, the Board of Tax Appeals said all you do is look to when you measure the accuracy of the statement, all you need to do is look to whether they met the contact period test and had a home outside the state for the entire year. Otherwise, there's no real bright line test, and we all know that was the purpose, is to get rid of all this ambiguity, add clarity. The Supreme Court then said, no, let's look at the common law test. It's, as Rich indicated, the intent to reside at a location indefinitely, and it continues until your present domicile, until you abandon it, establish a new one, and abandon the old. And the Supreme Court said that this bright line statute doesn't affect the core provision, the substantive law of domicile. And in fact, it's actually incorporated into the statute, the common law. That's how the Supreme Court read the statute, even though, again, all of us thought that there's no way. That was intended to add some clarity, to get us out of this facts and circumstances test with these extensive questionnaires and that we had to answer and the books of information. So the Supreme Court then, after making that finding that the common law test was incorporated into the statute, said all the tax commissioner has to do is identify one fact that's inconsistent with common law domicile. And I know the tax commissioner has taken the position in some of the statements that I've heard, is that they can consider any facts that would be inconsistent, even those facts that are not allowed to be recited in making the ultimate determination. You can consider any fact that's inconsistent with your common law domicile for purposes of rebutting the presumption of the bright line test, which essentially then eliminates the bright line test. But that's what the Supreme Court said. And in this case, the tax commissioner found, or the Supreme Court found, that there was a contradictory statement with respect to the homestead exemption, that therefore that affidavit that's filed, that third requirement, was false. And since this individual conceded that they had Ohio common law domiciled, the end of the analysis was there, that this individual was determined to be domiciled in Ohio, and the relevant income was subject to Ohio income tax. The dissent in this case jumped on that, noting that the falsity of the statement should be measured with respect to the two core requirements with respect to contact periods and having an abode outside the state. Otherwise, there wasn't enough certainty, and that's what the purpose for the legislation. So, where are we at? I've been on a subcommittee of the Ohio State Bar Association where we're working with introducing a bill to the General Assembly to add certainty, the certainty that we thought was intended in the original legislation. And that legislation we think is going to be introduced within the next few weeks. We've already submitted it to the governing board of the Bar Association for approval, and we expect it to be adopted. And we're also working with the estate planning group of the Bar Association, which also endorsed it. And two things are going to be in there, is that essentially the accuracy of the statement or the domicile affidavit is going to be measured with respect to having an abode outside the state for the entire year and meeting the meeting the contact period test. And common law domicile is not going to be relevant, and the statute explicitly states that if this is enacted, it's going to explicitly state that where your common law domicile, again, has no relevance. If you meet the contact period test, then you're considered to be a non-resident of Ohio. There was some discussion concerning addressing this major issue with respect to being deemed to be a part-year resident that Rich brought up. And it's really a subtle issue, very important issue, that the bright line test doesn't apply in any year that the tax commissioner can assert that you're a part-year resident. So you could clearly meet the bright line test, but if you move outside the state in February or March, and you have all your objective manifestations that are consistent with that, the tax commissioner can still play games with you as to what's the precise date of your change in domicile, and you still have to go back to that old common law test to show all these objective manifestations of your intent to establish a new domicile and abandon the old. And as Rich said, the best thing then is to sacrifice the first year before the year that you really wanted to meet this test. But we discussed having a provision in there that perhaps the tax commissioner should not be allowed to challenge or contend somebody's a part-year resident 2 years in a row. That would be inconsistent. But there was some concern about that provision. And we also had different provisions that if you still met the test, even under the contact period test, that where you had an abode outside the state, even though you may have been a part-year resident for common law purposes, you're still considered to be a non-resident for the entire year. And then the estate planning group had a further modification of that where you might prorate the contact period test. But ultimately, the pushback that we got was the intent of this legislation should be to clarify existing law. And so that would be a substantive change in the law to take away that tool that the tax commissioner has to attack that first year on a part-year resident status. So we've kind of backed off on that, and that's not going to be part of the legislation that's introduced. There won't be a part-year resident provision. But the statute will clarify, it'll state that it clarifies existing law, and therefore even the Cunninghams would have the ability to obtain a refund of any tax that's been paid. So what's the planning? Pending any change in the statute, as we're mentioning here, focus on supporting common law domicile prior to the year that you want to meet your contact period test. So if you contemplate that you want to be a resident in 2016, a non-resident in 2016, because you're going to realize a substantial amount of retirement income or income from sales of intangible assets, you probably want to take actions in 2015, perhaps support a position that you're a non-resident as of December 15th or December sometime earlier than January 1st of 2016, so that you can support that you're a part-year resident for 2015, and in 2016 you meet that contact period test. Theoretically, you still have the potential that the tax commissioner would argue that you're a full-year resident for 2015, under my example, and you're a part-year resident in 2016. It could still focus on that year that concerning the timing and try to attack when your effective date is to at least nab you on that first part-year residency issue. But it all comes down to, well, I should note also, as in this slide, it certainly helps if you don't have an Ohio home. I'm sure a common denominator in all these cases is having that connection to Ohio still, that Ohio presence. But obviously, the wealthier you are, the more it's tougher to get rid of a lot of those material things. And it's also, conversely, more difficult to prove what your objective intent is, because you're more mobile and you can keep all of your clothes and full clothing line and so forth at two different locations, and cars and other aspects. And sometimes it comes down to just little things like, where did you move your core personal items, your mementos, the family pictures? You want to take those types of actions as early as possible, in conjunction with the obvious items that are always recited, changing your driver's license and voting and so forth. But so it comes down to planning then with respect to income, planning when you're going to designate which date is going to be the date that you change your domicile, planning to implement that with those objective manifestations of your intent, and then also, just as important, if not most important, planning as to the receipt of the income and receiving it after you fully supported your change in domicile. So with that, Ron's going to talk about the pros and cons with respect to Ohio domicile and Florida domicile.
Thanks, Steve. So wanted to thank Rich and Steve for letting me coattail on their presentation. I'm going to talk to you a little bit about, the Florida aspects of this thing. And, I have kind of the lighter part of the presentation, and certainly these guys are great technicians. I just wanted to talk to you a little bit about some of the practical considerations in choice of Florida versus Ohio. So lots of times I get a call in my office. It's never in July or May that I get this call. It's usually in February, and somebody says to me, "Hey, Ron, the wife and I are considering changing our domicile to Florida." And I say, "Gee, Frank, why would that be?" And this is what they say, okay? So now, by the way, this is me trying to cut in front of all that traffic, okay? And that's the route that I would typically take on a weekday morning into Cleveland. So certainly weather is one of these considerations that people are always interested in. But there's more. They have an idealized version of Florida. It's always going to look like this. It will always be sunny and wonderful, and the beach will be always available, and there are no hurricanes and there are no fires. So, this is kind of what they perceive will be the situation when they move to Florida. Every day will be like this. And of course it's not. But there's another practical reason that comes up when people are talking about change of domicile. Believe it or not, they talk often about their kids and their grandkids. I want to be near them. Sometimes it's one spouse saying, "I want to fish and golf every day," and the other spouse is saying, "Hey, I really want to be near the grandkids." So kind of an interesting thing that's transpired since the elimination of the Ohio estate tax is that there would often be certain situations where husband and wives move to Florida. They want to avoid the Ohio estate tax. One of them becomes ill, passes away. The surviving spouse says, "I really want to be near the kids," so they come back to Ohio and they're taxed on the Ohio estate tax anyway. Now, all of that has obviously changed today because of the elimination of the Ohio estate tax. We'll talk about that in a minute. So the other issue is what? Healthcare. Sometimes people will say, "Geez, I've got an established relationship with a physician or a hospital. I'd really like to maintain that." And obviously, in different parts of Florida, there are various levels of care. The clinic and UH are everywhere these days, including Florida. But sometimes healthcare is an important consideration. So after you get past kind of these soft things, we start to talk about the real topics, which are what are the comparisons between Florida and Ohio in terms of the estate tax, in terms of estate planning, in terms of income tax. Well, Florida has no estate tax. I mean, to speak of, they have no estate tax, and it's constitutionally prohibited, so they're probably never going to have an estate tax. As we've discussed today, Florida has no income tax, so that can be a big, big game changer for lots of your clients and the people that we deal with. Florida also has an unlimited homestead exemption. Now, I hate to bring this up, but, what's the big unlimited homestead exemption case that always comes up? O.J. Simpson. Unlimited amount of homestead exemption against creditors' claims, against judgment creditors for a homestead, which is your personal residence in Florida. They also have a real property homestead tax exemption, but it's not a big deal. It prevents taxation on the first $50,000 of the value of the real estate, and it also limits the annual increases in real property appreciation to 3%. So those are some of the considerations. In Ohio, we now have no estate tax. I think you all know that. Effective January 1st of 2013, any decedent who dies in Ohio after that date is not subject to the Ohio estate tax. And this was a huge game changer as far as I was concerned and am concerned in terms of choice of domicile. The estate tax used to be this nasty little sales tax that would come upon the children. There was never a tax, as you know, on a transfer of property from a spouse to a surviving spouse. But boy, when the kids were going to inherit, basically 7% in excess of the amount of $334,000 was going to be lost to estate tax. So lots of people were assiduously marking their calendars to count contact periods in order to avoid the Ohio estate tax. The homestead exemption, income tax, and Steve pointed out to me that this is an old slide. It's now 4.99% is the maximum Ohio income tax. but again, can be a big number depending upon your circumstances. In Ohio, our homestead exemption is limited to $132,900. And believe it or not, it used to be $12,500. In other words, if you were sued, you could protect only $12,500 worth of the value of your residence. It's now $132,900, and it's multiplied by 2 for a husband and wife situation. Our real property homestead tax exemption is really quite modest. It's no tax on the first $25,000 of value, and I believe that in 2015 it's going to kick in that the homestead exemption is now going to be means tested in Ohio. So if your Ohio AGI is greater than like $30,000 or $31,000, you're not going to qualify for the homestead exemption. So that to me is a pretty, meaningless exemption in Ohio in terms of the homestead exemption. So there are actually advantages to Ohio estate planning, and this is just a quick little list here. We have a wonderful domestic asset protection trust called the Ohio Legacy Trust. Florida doesn't have one. Alaska, Delaware do. Florida does not. Ohio has wholly discretionary trusts, and again, without getting into a lot of detail, there's a situation where you can create a trust where the trustee has unfettered and complete discretion as to whether any distributions will ever be made to a beneficiary. Because the beneficiary can't compel a distribution, nor can a court, nor can Ohio Medicaid, and so it's a trust that's quickly replacing special needs trusts as a wonderfully flexible device in Ohio. Ohio has springing powers of attorney, which is a power of attorney which only springs into existence in the event of a disability or an incompetency, and Florida does not have that. In Ohio, if you're trying to protect a trustee, you can draft a trust with Ohio trust provisions that has shorter statute of limitations on breaches of fiduciary duty than does the Florida statute. So, it's what am I trying to accomplish? What are my ultimate goals? Can depend which choice of law you would pick for any of these situations. So how to memorialize Florida domicile? We've talked about this enough today, but the fact of the matter is that for Florida, it is really easy. You fill out a one-page form. My name is, I became a resident of Florida on such and such a date. I used to live at such and such a place. You file it in the county in which you intend to establish domicile at the county courthouse. Costs $10 and $3 for a certified copy of the certificate. So, that's a definitive declaration of domicile in Florida. There are other things that you should do, and they are, get a Florida driver's license, and just cloak yourself with indicia that you're a Florida resident, and certainly apply for the homestead Florida tax exemption, the homestead exemption. I'm going to, in the essence of time, and just because we've talked about these things, the next slides are kind of an indication of what if you're trying to prove that you're a Florida resident? You want that unlimited homestead exemption. These are the kinds of things that you would do, and they tend to be the exact same things that Rich was talking about that, should not be considered in establishing Ohio domicile. So these are the things that you would do in Florida in order to make yourself look like a Florida domiciliary. And they go on and on and on, and you can just read through those things. So the second most often question that I get about change of domicile is, hey, Ron, I got these great Ohio documents that you did for me, but I'm moving to Florida. Do I have to rework these things? Well, the answer is yes and no. Your Ohio will is certainly valid in Florida and every other state, but Florida has something called self-proving wills, which is an affidavit which is tacked on to the end of your will, and it means that the witnesses don't have to appear in probate court if you pass away. And it's just a way of streamlining the probate process in Florida. So often we will restate an Ohio will with the Florida formalities in order that those wills become self-proving. So it's not a question of whether it's valid or not. It's just that can we make it more seamless for you? And the answer is yes. Next question. Hey, I have an Ohio power of attorney. Is it going to work for me in Florida? Yes, but there are different laws in Florida relative to powers of attorney in Ohio, and you might meet some resistance down there with your old Ohio power of attorney. So, for example, Florida has the Uniform Power of Attorney Act, but they're really, really specific on what's called hot powers. So what is a hot power? The hot powers in a power of attorney are the game changers. They are You can change a beneficiary designation on a life insurance policy. You can make gifts on behalf of the principal. These are these things that can completely skew an estate plan with kind of one fell swoop of a pen. So in Florida, those powers have to be initialed. Not only do they have to be stated, they have to be initialed. That's not the case in Ohio. And certainly, there are statutory dates for these things. So old powers of attorney will probably pass muster in Florida. But after about 2013, the new statutory power of attorney law kicked in Florida. So is your Ohio power of attorney valid? Yes. But can we make it better? Yes, we can probably do that. Healthcare documents. My healthcare document in Ohio says on the bottom line, this document is valid in Ohio and every other state. So you don't have to redo your healthcare document, but if you're in a state that's not familiar, particularly with the Ohio format, it might be a good idea to reproduce those documents and have one for Ohio and have one for Florida. And we'd be very careful about the recitations in the document about where you live and where you're domiciled, but why not have two healthcare powers of attorney? The other change is that there's different anatomical gift forms in Ohio and in Florida. People are under the impression that they have a heart on their license, and so the only purpose for which organs and tissues can be donated is for transplantation only. That's not the case. That heart on your driver's license says that organ and tissue donations are permissible for any purpose authorized by law, and the purposes authorized by law go all the way down from transplantation to therapy, and then ultimately to medical and dental research. A lot of people should and do fill out Ohio anatomical gift forms that say, transplantation is fine with me, but that's as far as I'm going. So you can control and reiterate truly what your choices are relative to anatomical gifts. So we often do, duplicate powers of attorney for health care and living wills for Florida residents or people that spend time in each place. If you're a Florida resident, there's nothing wrong with having an Ohio healthcare power of attorney as well for the time that you're up here. And finally, so Ron, you did this 32-page trust for me, and now I'm moving to Florida. Is it going to be valid? Well, the answer is yes. Under the full faith and credit clause, it's going to be valid. But, just like every other state, Florida has some of its nuances, and one of them is that a trust is supposed to be executed with the same formalities as a will. And that, to me, means the self-proving affidavit should be on the end of a Florida trust. It's not going to make it invalid, but it certainly makes it easier to administer, particularly when it comes to the transmission of real property under a trust in the state of Florida, because there's some specific statutes that talk about trusts that handle the disposition of real property and that they need to be witnessed and hopefully even notarized. In Ohio, you can have an oral trust. As crazy as that sounds, you can have an oral trust. Never do that, okay? Never do that. We have enough trouble proving intent under written trusts in Ohio, but should your trust be reviewed? Absolutely. There are different provisions, different nuances, and you may have some provisions in your Ohio trust that are going to be difficult to enforce in Florida and vice versa. So, that's kind of the bottom line on choice of domicile in Ohio and Florida. Florida has no bright line residency test, so they do look at things like, so you're O.J. Simpson and you're trying to demonstrate that this is an unlimited homestead exemption. Where do you vote? Where do you attend church or temple? Where do you do these things? So, you cloak yourself with all of these indicia that you're a Florida resident. And the takeaway that from my piece of the presentation, and I think from Steve and Rich too, is that if you have clients contemplating a change, and I know we have lots of accountants here today and lots of financial professionals, please, you should give them the opportunity to express their goals and objectives and to have them determine what's of particular importance to them and help them make their decision before they make it so that they don't stub their toe. And we are here to help with that. So thank you very much. I'm going to turn it back over to Steve.
Thank you, gentlemen, Ron, Rich, and Steve. And I should mention, Ron is admitted in Florida as well as Ohio, so we really do try to stay on top of this. And Just to give you a little bit of perspective on history, when in 1992 I was on the State Bar Tax Committee, which Steve has now succeeded me on, and at that time, as Steve mentioned, we had a number of audits on this issue, and Governor Taft came to the State Bar Tax Committee and said, I can't take it. All of these audits are Republicans, not Democrats, and I'm getting a lot of pressure. We got to write a statute that buries this problem, and we wrote the statute that was overturned in the Chamberlain case, and in the course of the opinion, the court said this was not what the legislature intended. I guarantee you, irrebuttable presumption was what the legislature intended. But Steve is now chairing is on the committee that will correct that flaw. This program we are taping for the first time. We're going to be putting it on our new improved Buckingham website. So if you or others are interested in the program, you should be able to see it there. There are evaluations included in the materials that you have here, so if you could take a moment and complete those evaluations, we'd appreciate it. Any suggestions for future topics would also be appreciated. Steve and Rich both mentioned the possibility or the importance of your burial place, and many of you may know that Yogi Berra passed away recently, and I'd like to end the program with a quote from Yogi Berra. He was asked by his wife where he'd like to be buried. He said, surprise me. I know many of you have to go, so we'll adjourn the program at this point with questions. I did want to take a moment. I'll let Steve plug the State and Local Tax Conference.
A few years ago, we realized that Northeast Ohio does not have a comprehensive state and local tax conference for one day. And so 2 years ago, we started that in conjunction with the Ohio Society of CPAs and the University of Akron, and we're also a sponsor. All the money goes to both of those nonprofits. So we have a comprehensive state and local tax seminar on November 12th. Matt Chafin, who's really the top person in the Department of Taxation, will be speaking. He's just below the tax commissioner, but he really makes all the decisions. And all of the areas of Ohio, state and local tax, are going to be covered, as well as a multi-state tax track. So it's very good. It's our third annual, and a brochure is in your folders. Hopefully you can attend. Thank you.
So Steve, Rich, and Ron will stick around for a little bit if you have some questions. Thanks all for attending, and enjoy your day.